In negligence law, the plaintiff generally bears the onus probandi under Section 101 of the Evidence Act 1950. But in modern medical and technical cases, this is often very difficult because the facts are usually entirely under the defendant's control, as Lee noted in 2012. Res ipsa loquitur, meaning the thing speaks for itself, allow courts to infer negligence even when the exact act cannot be proved. By and Border 1863 shows how the mere occurrence of an accident can establish a prima facie case. Modern systems create a complexity wall. Exclusive control seen in Vibara and Spengler is hard to prove. Rebuttal varies as in Scotland and London, and in Malaysia, the uncertain application of English law under Section 3 of the CLA 1956, illustrated in M.A. Clyde and Wong Ahmed, adds unpredictability. As a result, victims may struggle to prove negligence, and res ipsa loquitur often depends on judicial discretion rather than clear standards.
Let's start with methodology. This study adopts a qualitative approach, focusing on non-numerical analysis of judicial reasoning and legal interpretation. It examines the idea of a silent breach where negligence is inferred rather than directly proven, particularly in medical and technical cases. This approach allows the study to capture the deeper judicial reasoning behind the application of res ipsa loquitur. The research uses a doctrinal or black-letter law methodology, tracing the development of res ipsa loquitur from the case of London and St. Catherine Dogs Co. 1865 to its modern application in modern courts. This helps explain how the doctrine has evolved to address complex cases involving evidential challenges. The study relies on primary sources such as statutes, which is the CLA 1956, and court decisions and secondary sources including authoritative textbooks and journal articles. Data was collected and verified through reliable legal databases like LexisNexis via the UKME's resource portal, ensuring accuracy and credibility.
Now let's moving on to the literature review. So res ipsa loquitur is a common sense rule in negligence, not a law. In Malaysia, it helps to establish a prima facie case but doesn't automatically make the defendant liable. So for the tripartite test, we believe that to apply this maxim, there are three requirements that need to be satisfied, which are: the first one is the accident must usually not happen without negligence. The second one is be under the defendant's control. And the third one is be unexplained by the plaintiff. So all these three requirements must exist. So for the procedural impact, we believe that the evidential burden shifts to the defendant, but the plaintiff still carries the legal burden. A reasonable explanation can rebut the negligence itself. So last but not least is the research gap. We believe that the modern team-based cases show unclear control, highlighting the need for clearer judicial guidance.
We are currently witnessing the rise of the silent breach. In our modern world, the how and why of an injury are often hidden inside a black box of complex technology. Under Section 3 of CLA, the victim carries the burden of proof, but the defendant holds all the evidence, leaving the victim in a total evidentiary vacuum. To bridge this gap, we use RIL. This doctrine allows the facts to speak for themselves, piercing the defendant's veil of ignorance when they refuse to explain a failure. It was designed as a bridge to ensure that a lack of direct evidence doesn't mean a lack of justice. However, this bridge is being eroded by the complexity bar. Defendants now use technical obfuscation as a shield, arguing that if a system is too complex, the negligence is not obvious. This creates a catch-22. If a plaintiff proves too much, they lose the doctrine's protection. If they prove too little, the court rules the case is too technical for justice to reach. Here is where it gets really interesting. I found something I call the complexity bar. It is the idea if a machine is too technical or too smart, the court won't apply common sense. In IOI City Mall 2023, we see that if an accident is not obvious like a falling barrel, the maxim is rejected. This is a dangerous black box incentive. It basically tells companies the more complicated you make your systems, the harder it is for us to sue you. I argue that complexity shouldn't be a shield. If your robot or your AI fails, you shouldn't get a complexity pass to avoid explaining what happened. In surgery, an unconscious patient is the ultimate victim of the silent breach. Historically, cases like Cassidy and Mahon Osborne protected this vulnerability, ruling that if you enter for a routine procedure but emerge with a disability, the hospital must explain why. However, Ashgar Ali warns that this protection is being defeated by the professional standards defense. Recent Malaysian shift is Lu Chuigai and Kanagaratnam suggest that if a procedure has a statistically recognized risk, RIL is denied. Ashgar Ali argues this creates an undue burden. By using inherent risk as blanket immunity, the law builds a technical wall. We are left with a medical catch-22. Patients are now legally required to provide expert testimony for events they were physically unconscious to witness. In industrial failures, physical possession is not everything. In Abdulaziz and TNB, the court applied RIL by looking past the natural rainfall to the systemic control. The defendant held over the dam's gate. They recognize that while nature is wild, management is an artificial process. However, Ashgar Ali warns that this is being undermined. In cases like Ahmad Zaki resources, defendants use multi-contractor sites to argue they lack exclusive control, creating a major loophole that smokes out the victim instead of the truth. Today, as seen in Tom Iswin, wealthy defendants use maintenance logs and technical jargons to bury plaintiff. They use an information monopoly to offer unverified explanations that a layperson simply cannot challenge, keeping the silent breach hidden.
First, judicial reform. The traditional requirement of exclusive control under res ipsa loquitur is outdated. Control today is often informational, not physical. I propose an information monopoly test where the defendant alone control access to data capable of explaining the harm. Exclusive control should be presumed. This is then justified by substantive equality, as noted in Lufthansa and GKN 2023. Modern systems are impenetrable to laypersons. Ignoring informational control rewards black box operations. I also propose raising the rebuttal standard. Defendants should be able to provide probable evidence of care, not speculative explanations. This is consistent with Chun Pui and Lee Chun Tat. Second, legislative reform. Malaysia should codify res ipsa loquitur in specialist actors through amendments of Civil Law Act 1956. This would enhance legal certainty, especially in light of recent judicial skepticism, such as in Tom Iswin 2025. In addition, a statutory duty of candor should be introduced in healthcare. Silent breaches often persist because of professional non-disclosure. This aligns with Fontaine against British Columbia and reinforces patient autonomy from a law and economics perspective. The proposed independent technical panels under professional bodies to provide neutral incident assessment. This addresses the problem of partisan expert battles, highlighted in Foster against Biosil. Neutral expertise give courts a reliable baseline of determining ordinary negligence. Other than that, I also recommend strengthening the pre-action discovery under the rules of Court 2012. Early disclosure of logs and data exposes silence breaches, quickly saving the time and cost. This then reflects the transparency-driven approach of the UK's Lord Wolf reforms. These reforms transform res ipsa loquitur from a passive maxim into an active tool of accountability. Under the current system, silence benefits defendants. Under the proposed system, silence becomes a liability. This creates incentive for safer system and transparent reporting. At its core, this is some distributive justice, as stated in Schellenberg against Tunnel Holdings. Res ipsa loquitur exists to do justice when plaintiffs are in the dock. The risk of silence breaches should rest with those who control and profit from the system.
So as for the conclusion, the silent breach shows that res ipsa loquitur is being challenged by modern technology with surgical robots and automated systems make the old idea of exclusive control outdated. This isn't just legal technicality, but it's about fairness. Complexity shouldn't shield negligence. By using the information monopoly test and stricter rebuttal rules, courts can ensure victims are not blocked by the burden of proof. Res ipsa loquitur must evolve so the law still protects those who cannot speak for themselves.